know what she said, she might just change your life.
And now it is time for The Legal Beat with Neuberger and Partners, LLP. Plain talk about legal, liberty, and social justice issues that impact all Canadians, what we need to know, and what we want to talk about. And we have Joseph Neuberger himself in studio today with us. A pleasure, as always, to have you here.
Thank you for having me.
Months ago, issues were raised about how the government, Crown prosecutes sexual assault cases. And you've defended a lot of people in sexual assault cases.
Probably about 700 cases, yeah.
How old are you?
I'm 48, but at the beginning it started, so it's over 23 years. It's amounted to a lot of cases.
That is a lot of cases. Yeah. So what do you, and we've seen the Crown drop charges in the Jean Ghomeshi case because they didn't think that they
had sufficient evidence or enough to proceed on.
So what do you think the issues are around, because when we hear that charges have been laid and then we hear that they're dropped, it sort of raises a whole lot of questions in just the average person's mind about, well, what's really going on here? Why would they charge him and then drop the charges?
Yeah, well, in that case, as we discussed before, it's probably the sufficiency of evidence. But
right.
what dialogue started with the government and Crown attorneys months ago was to now take a fresh look at how the Crown prosecutes these types of cases. And we're not just talking about something as high profile as the Ghomeshi case, but we're talking about generally how they're prosecuting sexual assault cases. And there's actually a team put together from Crowns from various areas to take a look at how they're going to do it. And there were a number of issues raised about whether victims, but before that's decided in court, we refer to them as complainants, should be having their own lawyers, etc. But what I find interesting and what may get lost from the dialogue is that, again, regardless of a charge, so whether it's a sexual assault, an assault, a drug case, we don't lower the threshold or the burden of proof beyond a reasonable doubt, which protects everybody.
Right.
And it can't be lowered regardless of the type of charge. And generally, me having defended somewhere near 700 of these types of cases, I have not really witnessed judges or prosecutors treat complainants or witnesses in anything but a respectful way, and any decent lawyer who knows how to do their job is not going to beat up on a complainant in the stand, because it does nobody any good to do that. But what gets lost so much are the resources which are put into investigation. And that also has to be part of the dialogue, and which we've seen a little bit coming out now in these discussions. And what I noticed in a case recently, which I did, where my client was acquitted, but what was patently obvious, just to give you an example, it was a workplace type of sexual harassment that culminated in 2 days of alleged sexual assaults. And so all of it was alleged to have happened at a workplace. And amazingly, when I was cross-examining, and I knew all this ahead of time, but I got out through the witness that there was no co-workers interviewed. There was cameras and surveillance in the business location where the investigating officers did not go and see if there was any video. And although where the alleged sexual assaults occurred, there was no surveillance, but if you see somebody running away from a certain area, you can capture their demeanor, if they're disheveled, unhappy, upset. All of that is evidence which would be supportive of the Crown's case. So that wasn't done. And there was issues as to whether, in fact, my client was actually in the business when this happened, and I had obtained from my client's phone through the use of a forensic technologist certain social media messages which had come to my client from the complainant. The complainant actually deleted all of her messages to my client, but only handed over my client's messages. And the police never seized her phone, and they should have said, can we have your consent to get your phone just to take a look at, see if we can retrieve these messages. And so I did that with my client, and I was able to show that the timing was completely off, and most likely in my case it was not true. I'm not saying that across all of them, but it's a very good example. And the police didn't even seize the worksheets. There's timesheets where my client was going out to job sites and would not have been there, so they didn't even seize the schedule. So that speaks to one of two things. One, either we are not having sufficient resources for our police services to do thorough investigations in sexual assault cases, or it goes to a belief system that in certain types of cases, the person who's complaining ought to be believed and will be believed no matter what, so we don't need to do any further investigation. And there is some of that's out there when it comes to younger victims and in sexual assault cases that unfortunately nobody ever lies. There's never really a motive to fabricate, because who would want to put themselves through this system if it wasn't true? And so we might have a myopic view which leads to a very limited investigation, which is something which a defense lawyer like myself can certainly take advantage of, because there is no investigation. And from certainly a democratic perspective, for our society, if we want to ensure that the people are being convicted beyond a reasonable doubt of compelling evidence, in other words, we're getting the right people, we should have thorough investigations to assist either judges or juries to make the right decisions.
But that goes back to your first point, where you said that maybe we don't have the resources, and the police are always saying that they don't have the resources.
And they're right; they're inundated, and they have a new software system which is actually quite archaic and not easy to work with. They don't have assistants like they need. They don't have enough time to deal with all the cases they have. And so when we talk about in the politics, when we talk about creating new crimes and new legislation to try and combat this issue and create some sort of victims' bill of rights, that's really nice for politics, but does nothing down in the trenches where the police are trying to do the work. So really a lot of focus has to go on the resources that are put into some investigations. And I'm not saying all of them, because many investigations are done very thoroughly, but I've seen this a lot in domestic and sexual related cases where you have a very anemic investigation, and it's very easy for a defense lawyer like myself to take advantage of that.
So, Joseph, how much of this would have to do with training, the training of police officers?
That's an excellent point. So training is necessary. The police service is very good about training. I've actually attended the police college on a few occasions and spoken about how to conduct investigations, spoke about crime scene investigation, about proper note-taking. So they're engaged in that. But again, it's a question of resources. There's a lot that the police have to deal with, and they probably need expanded training through the process where they're coming in to be a police officer. And then just like we have continued legal education, they need, and they are getting continued training, but they need some more intensive training with respect to these types of offenses. And they have set up specialized units who are more trained than others, but these don't always go to the specialized units.
And what about, let's see if we can sort of verge onto cultural issues, because what about people that are investigating crimes that involve a different culture, particularly domestic issues?
Yeah.
So how much more do we need good research, good background for solid charges that will stand, or how much do you need to form a good defense, or where do we cross the line? Because quite often I'm thinking of honor killings in quotes, that we don't really understand what goes beyond, and we have so-called experts that appear in court to tell us about it, but that may not prejudice a jury, but if a jury is meant to believe an expert, how much weight do we give them?
Yeah, so let's divide that into two questions, because it's a good question. So one thing is we have diverse police forces, so we've got good representation from communities on it, and sometimes you'll see certain officers on certain investigations, so there's more cultural sensitivity when they're investigating, and you have to be aware of the culture of a particular family, because it impacts how people think and how people react, and then what will ultimately happen in a prosecution. What you're talking about are the honor killing cases, and I did one a number of years ago in Brampton, but there's the recent one which is now in the news where the 4 bodies were in the car.
The Shafia family.
Yeah.
Yeah, they're asking for, they were all convicted, a father, mother, and the son were all convicted of first-degree murder in the deaths of the 4 members of the family that were found at the bottom of the canal, saying that the expert witness, the evidence should not have been admitted.
Yeah, it's an incredible push in these cases to label these honor killings and to have experts who are professors or anthropologists testify about what this is in other lands like India or Pakistan or other countries, and that this is motivated by a cultural belief. The difficulty I have with that, when I faced it in my case, the information that I was looking at from the expert was basically anecdotal, didn't reach any sort of scientific basis that should be allowed in court. And I never saw the sense in yet creating another label. It stigmatizes a community, and I don't think, and it detracts from really what you have to look at in a case, because if a jury is hearing from an expert, juries have a tendency, like you said, to be more deferential to an expert, and so that may have more weight, even though their evidence may be about certain people in certain communities in other countries that may not apply here. I don't think it helps at all. I think it detracts, and it can lead to convictions when maybe there shouldn't be a conviction. But in a case like this, evidence is overwhelming, and you don't need to call it an honor killing. You don't need to call an expert to create that type of label. Any domestic homicide is a breach of trust. It's terrible. The motivation is still the same. You can still lead evidence saying that the family was shamed by the daughter's actions, that she was rebellious, and that was the motivation for the homicide, without calling it an honor killing. I think it just is an unnecessary detractor from a trial, can cause a jury to place more weight in it. If there's an identification issue, whether it's a whodunit, they just may be overwhelmed, because the honor killing, even though the expert is speaking in general, they're relating it directly to the people who are sitting in the box, who are all from Pakistan or wherever. And so it creates a sympathy for, of course, for the victims, but it creates a bias, a prejudice towards the accused. And I think that needs to be avoided. We need to have clean convictions, and we need to ensure that the evidence is cogent and compelling and admissible, and not for the purpose of stigmatizing. And I just don't see the value. And they may very well win on that point.
So you think, if we go back to the case, tell us a little bit about the case that you did. That was Aksa Parvez?
Correct, yes.
Her murder. Now, her father basically said, I killed my daughter with my hands. He said that, and his blood and DNA was there, but it was more than the fact that she wouldn't wear the hijab. It was more, and he had tried to get help to keep his family together. But
yeah.
everyone just labeled it straight away that this is an honor killing.
Right, but there's very good points here. So we've got a moment for this. So it was actually the father and the brother of the victim, and there were confessions, and there was evidence which was overwhelming. So that's why we went into the mode to try and resolve this. But what came out actually was that for some time leading up to the death, this young lady, the victim, was leaving home and not coming home. And so the family went to the school, and certain agencies were engaged to try and help. But what the help was to find her another location to live, to try and support her, which I'm not saying is wrong, but there was no understanding of the disconnect in the family. The family had come here from a particular culture with particular beliefs. They had not been acclimatized to Canadian society, and they needed their own time to acclimatize, and some sort of mediation, some sort of cultural sensitivity would have been very helpful, to have people sort of mediate with the family to say, well, your beliefs are not, it's very hard to do this. You can't say your beliefs are wrong, because we try and accept everybody's beliefs, but certain things I think we can, from a Canadian perspective, say we're not really in support of that. But if you have more sensitivity towards their culture and their conceptions, then a greater intervention maybe could have been done to try and bridge the gap between the daughter who's with Western society and is going to school with kids who dress differently and want to behave differently, and what the beliefs were from parents who came from a very different culture. And I think greater effort could have occurred in that regard, and I'm sure now there's more sensitivity in that regard to help families making this transition. And fortunately, this type of event is rare, but it is needed. And again, by continually referring to this in the media, and to try and call experts about honor killings, I think is creating a label and a stigmatization which is not going to help.
Well, it definitely creates a label, because as soon as I hear that, I go, okay, so then I understand well, I don't necessarily understand, but I know what the culture is, I know where they're coming from, and I've almost blocked it off in my mind. It's like, but there could be so many other underlying issues that went with that case. You're right, domestic violence should be enough, right?
Domestic violence is just bad. I mean,
Yeah.
and if you kill a child, it doesn't get worse than that.
No,
I mean,
it really
so you don't
doesn't.
need to call it an honor killing. It's a domestic homicide. It's horrible. It's an incredible breach of trust. It's very, very bad. But we need to be careful to ensure when we do prosecutions, proof beyond a reasonable doubt is the goal, and we don't get there by using, I don't want to say tricks, but by using certain pathways that will infect a jury with some prejudice. It's not necessary, and it's not good for our system.
Well, the trial judge in the Shafia case, he said that he described the killings as being motivated by the family's, quote, twisted concept of honor.
Right.
So,
Not helpful.
No.
Not helpful. I mean, he's clearly making a value judgment and characterizing evidence, and there's no doubt that to many people it's incredibly offensive what the family said. But you can say it in different ways. You can say it was motivated because the family felt that the daughter should not be doing the following. That's the motive to the killing, instead of twisted and making these value judgments that I think are unnecessary in our system. When we talk about being respectful to a witness, to a complainant, or in the stand who's testifying, it goes both ways. We have a very good system of law in Canada, and we've shown very good respect for witnesses, for complainants, and for accused persons. And we need to maintain that type of civility and respect for all players in the system to maintain a good system of justice.
How do we do that?
Yeah. That was going to be my question.
I'd say don't use this type of language.
Okay,
Avoid it as much as possible. If you want to use it on sentencing, that's one thing. Do not instruct a jury that way. And try and avoid experts where it's evidence that's really not helpful. It's fluff.
Okay, but where do we go from here? How does that get woven into the fabric, the institutional fabric?
Well, a court of appeal will carefully scrutinize the evidence, and they may say that whether the expert evidence was admitted or not, these individuals would have been convicted because the evidence was overwhelming no matter what. But the court of appeal can take the opportunity to say this type of expert evidence is not legitimate and should not be admitted, but regardless, it didn't affect the outcome of the trial, and they can make a very strong statement about that. And courts on appeal have always made good statements about what's appropriate for judges or prosecutors or lawyers to say in a courtroom during the course of a case. But I think as a society, we have to have a greater discussion about what we want from our justice system, and have a greater dialogue out there to say, this type of evidence is not necessary, and we can voice it in many ways. I mean, we've got social media,
Well, in the case of Aksa Parvez's murder, the Crown, and I have it here, Marabasso, is that right?
Yeah.
I mean, her wording, she told the court that the chilling gender-based crime was motivated by patriarchal concepts of honor and shame, and embarrassment to the family is enough to warrant murder. How did you respond to that?
I was just quiet, I'm in a sentencing, and she was right, and she's a very polished Crown attorney. We avoided expert evidence on the sentencing. We agreed on what the disposition would be anyway, so I wasn't so worried about what she was saying. And she said it in a little bit more of an elegant way than we've seen in other cases. But again, there's ways to describe it. There was more to this death than simply, these archaic type of gender-biased beliefs. That being said, it was motivated because they wanted their daughter to behave in a way that was commensurate with their cultural views. And when I was on camera afterward and I spoke about it, I spoke strongly about why honor killings is not a label we should be attaching to this. It doesn't help. It's going to take time because we're dealing with an influx of individuals from other countries where they have to get used to our culture, and we have to find a way to meld everybody and still protect everybody. So it's going to take time, but it needs an ongoing discourse.
So you think the Shafia family has a chance?
Well, I don't think, admitting that expert evidence, I think, is a legitimate ground of appeal to say how did it affect the jury. When you take it into, if you're looking at overall identification and how the prosecution got their convictions, that expert evidence can be a factor which, if it wasn't there, might not have prejudiced a jury against them.
I think of the baby shaking cases and what we found out, from the coroner and the cases afterwards that all got overturned because of one, quote, expert's opinions about how these babies died, which was completely wrong.
Yeah, well, that expert was horrible, and that expert lied.
Yes.
And went on his own mission, and there was no checks or balances to him. But you see the power of an expert, and we see the power of language. Language is incredibly powerful. It's emotive. We use, as defense lawyers, I use things in closing addresses to juries to evoke emotions, to acquit individuals. When we talk about our democracy, same thing is powerful for the prosecution. We need to have more neutral language. Evidence speaks for itself. It doesn't need to be dressed up in certain ways, and to avoid that type of language, gives us cleaner trials where we can be more secure in the convictions that come out.
Joseph Neuberger, thank you very much.
Thank you for having me.
And that is today's Legal Beat, brought to you by Neuberger and Partners, LLP, one of Canada's leading criminal defense law firms, expertly defending clients since 1992. Visit them online at nrlawyers.com.
Click the channel subscribe button for full-length interviews and more from What She Said here on YouTube.